we weren't able to get on that agenda for a couple of reasons. One, department requested additional information from our law firm, and by making that request, they said that they did not consider our application to be complete. So in consultation with our experts, they were able to fulfill that request and filed some additional information with DENR. But we weren't able to make that March meeting then, in part because of that, and also because that March meeting agenda was full with people fighting about other things. It's a busy board. So once it was determined that our application was complete, then we were looking at being on the agenda for the May meeting. And our attorneys made the decision that it would be better to wait until the July meeting to have the hearing. And so I would anticipate that that application will go before that board in July. At that time, at that hearing, the parties involved, which would be the Lake Ponset Water Project District, and our lawyers and experts would appear before that board, and then those who would oppose the application would appear as well. And my understanding is that that board could make a determination fairly quickly after that with respect to what they want to do with our application. Maybe I should back up. What we are requesting in our application is not to remove the gate, but to look for some common ground on being able to open that gate when the lake water is low for it isn't for a period of time, but based on some water flow. And for those who would like to obtain a copy of the application that was filed, you can get that from DENR, either by calling them or I think probably going on the website, and they will make available to you a copy of that application and any correspondence that they have in their file with respect to that application. So it's public record. Anybody's entitled to it. With respect to our attorney and experts that are here, the board felt it was important that they be here today to answer questions. But I will tell you that it's certainly possible that there will be questions that they will not respond to because this is considered a contested case, in which case parties are not exchanging certain types of information that could be deemed strategy or attorney-client privilege. And that information then would become available at the time of the hearing. So, I guess first of all, because we got started late, trying to figure out how to make this voting process work, I was hoping to be done by 12. But we got started late, 15 minutes late. I think that whatever discussion we want to have about it, I can't believe that anybody in the room hasn't expressed an opinion one way or another. And I'm unfortunate about that. That's because we really work with it. But any comments from any of the board members before we, one way or another? First first of all, I guess, do you have any questions? The people that, Jeremy, you want to introduce yourself?
Good morning. I guess it's still morning. I don't have my watch on, so I don't know if we're afternoon yet. My name is Jeremy Pancratz. I work for the firm of Glover and Helsberg in Brookings, South Dakota. Our firm was hired to go forward with looking at ways that the board can utilize the gates to maintain lake levels. Through discussing with our experts what particular routes we wanted to go, the firm has filed 2 applications. One is a modification of flood control permit 5, FC5, and the other is a water use right that also involves the gates. In discussion with the DENR, game fish and parks, and the experts, those 2 particular aspects were filed. Now, as to the reasons that we filed those particular applications, the process that we've gone through to discuss with our experts why we think those are the most appropriate, as well as information that we've gathered that we will be providing at the particular hearing in July. Much of that, again, is considered work product of the firm and is not necessarily open for giving to the public at large at this time. The board is a quasi-governmental institution. Anything that has been made public by the board is discoverable to anybody who wants that information. As Mr. Pancratz indicated, that can be obtained from the DENR or that can be obtained by contacting the board that we're going in front of in July. As to information that our experts have come up with at this time, unless there is a listed adversarial party, we are not giving that information out. It will all be made public at the July hearing. Anybody who wants to be present for that, that is a public hearing, and you can certainly be there and have your information be known to the institution at that time. With that said, are there any questions at this point as to how the process is going to work? Again, I'm not going to discuss any information as to how we're going about with the trial, or excuse me, with the hearing. But is there any general questions as to what we went forward with?
My question is just, are the documents that you filed wrong, wordy documents? I mean, you said we could get them to the DNR. Are they?
We are attorneys.